Wondering how a U.S. citizen child over 21 can petition for their parents' green card? Watch the video, get a complete guide on filing, timelines, and essential steps for parent adjustment of the status. Have questions? Drop them below. We're here to help. Hi, I'm Attorney Jay Francis. I'm a U.S. immigration lawyer based in Chicago, but serving all 50 states. Today, we're breaking down everything you need to know about parent adjustment of the status for U.S. citizen children who are 20 years old or older. This video is for those of you who want to bring your parents to the U.S. as lawful permanent residents. We're here to make the process clear and straightforward. At Francis Law Center, we specialize in family-based immigration. Understand how crucial it is to reunite families. Let's jump into the steps involved in getting a green card for your parents, what's needed, and how our team can support you through the process. Today, we're breaking down everything you need to know about parent adjustment of the status for U.S. citizen children who are 20 years old or older. This video is for those of you who have a parents already in the United States and ready to start a green card process now. We're here to make the process clear and straightforward. At Francis Law Center, we specialize in family-based immigration and understand how crucial it is to reunite the families. Let's jump into the steps involving getting a green card for your parents, what's needed, and how our team can support you throughout the process. Number one, can a U.S. citizen child over 21 petition for parents? The short answer is yes. If you are a U.S. citizen who's 21 or older, you can petition for your parents to adjust their status and receive a green card. This type of petition falls under the immediate relative category, which means it is not subject to visa availability limits. Fantastic. That's great news because unlike some other family petitions, this classification allows the process to move faster without waiting for visa to become available. If you're ready to bring your parents to US and they're here, let's talk about what comes next. Number two, how do I file a petition for my parents' immigration? If your parents enter the U.S. with a valid visa and either overstay or are still in valid status, here's a step-by-step guide to adjusting their status to permanent residency. To adjust your parents' status to permanent residency while they're already in the U.S., you can file both I-130, 45 forms at the same time, a process known as concurrent filing. Form I-130, the petition for alien relative, establishes the parent-child relationship with the USCIS. By filing Form I-130 and Form I-45 together, you streamline the process, allowing your parents to stay in the U.S. while waiting for their green cards. Concurrent filing means your parents don't need to leave the United States to complete the process. Lifesaver. It can potentially reduce the waiting time, another lifesaver, by allowing the two applications to move together. Our attorneys at Francis Law Center will assist you with every step, ensuring all paperwork is completed accurately and on time to avoid any unnecessary delays. This is important because any errors made in these forms can cause setbacks. So professional guidance here can make a big difference. Number 3, how long does it take for U.S. citizens to petition for parents? This is a very common question. How long will it take for my parents to get their green card? Perhaps your parents waited long time. We have many clients waited literally 21 years for their children who are born in the U.S. to reach 21 years of age. So, you're almost there. You'd like to know about the timeline. Parent green card timeline changes all the time. But now it is a good time. Why? Because it takes about 6 to 12 months. 6 to 12 months right now, depending on several factors. This time frame depends on how quickly USCIS processes the forms and supporting documents, and whether they schedule interview for your parent cases or not, and also reflecting the strength and issues of your parent green card case. We understand the importance of keeping families together and informed, so our team will guide you every step of the way to help minimize delays. Number 4, what if my parents entered without inspection? Do they need a 601A waiver? This is very important issue. If your parents enter the U.S. without inspection, things can get a bit more complicated. Generally, parents who enter without inspection are not eligible for adjustment of the status, so they may need to pursue consular processing instead. However, if your parents have accrued unlawful presence, they might need a 601A waiver to return to U.S. legally after leaving for consular processing. But this is essential point here. Pay close attention to this. Unfortunately, a U.S. citizen child is not considered qualifying relative for 601A waiver. That means the waiver cannot be based upon hardship to you, U.S. citizen child. This limitation makes this process more challenging, so that it is critical to work with experienced immigration attorney who can assess your options and find the path for your family. Repeat one more time. U.S. citizen child may petition for their parents when they turn 21 and older, but you need 8 different qualifying relatives for 601A waiver if your parents enter without inspection. Number 5, what if the U.S. citizen child didn't make enough? Using a joint sponsor for A64 required? For this process, the U.S. citizen child must submit the form A64, Affidavit of Support, to show that they meet the income requirements for sponsoring their parents. But U.S. citizen child may be still in school or looking for a job. So what if your income doesn't meet this minimum requirement? U.S. citizen child didn't work and didn't make enough money. Maybe your U.S. citizen child has a serious medical condition, prevent your child from working. So, what's the solution? This is where a joint sponsor comes into play. A joint sponsor is someone who can step in and meet the income requirement for your parents' application. They must be either a U.S. citizen or lawful permanent resident and have sufficient income on their own to qualify as a joint sponsor. Our team can help you identify eligible joint sponsor and ensure all financial requirements are properly met. But don't forget, your U.S. citizen child must be a sponsor. And if your U.S. citizen child didn't make enough money, then you need to find a joint sponsor. Thank you so much for watching this video. We'll be making more videos on family immigration cases, humanitarian visa cases, and removal defense cases. Thank you.